When one reflects upon the notorious 9/11 attacks, insurance coverage doesn't usually come to mind. However, the 2006 case of SR International Business Insurance Company versus World Trade Center Properties LLC explores some of the issues associated with that particular tenuous insurance coverage under contract law principles. World Trade Center Properties and several other companies with property interests in the Twin Towers were in the final stages of negotiating property coverage insurance policies for the World Trade Center with multiple insurers. The insurance companies, including SR International, issued temporary insurance contracts for interim coverage until the parties agreed upon final policy terms. These interim contracts, known as binders, were fully enforceable and provided coverage on a per-occurrence basis. Specifically, the property companies could recover up to $3.5 billion per occurrence. During final negotiations and prior to issuance of the final policies, the World Trade Center was attacked by two terrorist aircrafts on September 11, 2001. The planes crashed into the Twin Towers separately. Although the damage well exceeded $3.5 billion, the binders, which comprised the governing contracts at the time, didn't define the term occurrence. As a result, it wasn't clear whether the attack constituted one or two occurrences, and whether recovery up to $7 billion or $3.5 billion was covered. Two distinct policy forms, included in the underwriting submissions, were relevant to the missing definition. Some of the insurers involved utilized the will prop form, which defined occurrence as a cause or series of causes, while others used another form that either defined occurrence differently or not at all. About a month after the attacks, SR and other insurers sued World Trade Center Properties and the other property interest holders in district court, requesting a declaratory judgment that the attacks were considered one occurrence. Several counterclaims were filed. The court found that insurers who used the will prop form were entitled to judgment as a matter of law that the attacks constituted one occurrence. Those that used the other form would have to cover the attacks as two occurrences. The court also allowed witness testimony regarding which form the parties to the negotiations thought applied. Both the insureds and the insurers appealed to the Second Circuit.